Good morning. I'm just gonna wait for you guys to tune in. Welcome everyone. Happy Memorial Day that just passed yesterday. Hope you guys had a great time off. I've personally been a little under the weather over the last week. Feeling better today, thank God. But come on in, guys. Come on in. Good morning, Vondi on Facebook. Rayon, good morning. DJ Steps, good morning. Chill MBO, good morning. If I start to cough too much, I'm going to log off, but I'm going to power through today. So my name is Aisha Chidole, and I'm an immigration attorney. I represent clients all over the U.S. and internationally with their immigration matters. If you have an immigration case, I'm happy to assist you. My number here is 407-995-6567. You can also send a WhatsApp to 404-333-8751. My number is scrolling through the ticker. Let me actually just put that in there. And you can also see it if you're not watching this live. You can also see this in my profile on Instagram. Good morning, Lady Bishop. Good morning. So feel free to ask your questions, guys. How's everyone doing? I see a question here. How long does it take to get a work permit from a valid case? If you file an adjustment of status with your work permit, with your valid case, excuse me, then it takes a shorter time. It can take 4 to 9 months on average. It means that sometimes some people are going to get it before 4 months. Sometimes some people are going to get it after 9 months. But most people will fall into the 4 to 9 month average. If you didn't submit an adjustment of status application, which your VAWA petition, then you won't get a work permit until they approve your VAWA case, and that can take 2 to 3 years. So that's kind of how the timeline goes. Kenan says, speedy recovery. Thank you so much. I appreciate it. If your partner stayed over their 6 months of visitation in the U.S., will it affect their case negatively? It could, because I need a little bit more. It depends on what whether you filed already for your partner or you haven't. If you're a U.S. citizen and your spouse has overstayed their time more than 6 months, but they entered into the country with certain types of visas, like a tourist visa, H-2B visa, you can file for them even though they have overstayed their time. Now, if you're legal permanent residents and they've overstayed their time, it will affect their case, because they're not going to be able to adjust their status as an overstay. They're going to have to go back to, their home country and, finish the process after they get, a hardship waiver approved, unless they qualify for another humanitarian-based petition like VAWA U or T, and then they're applying through that basis. If you get a 2-year green card, how long can I apply for a 10-year green card or citizenship? So if you get a 2-year green card, which is a conditional green card, typically you have exactly that, 2 years to apply for removal of conditions to get your 10-year green card. Eligibility for citizenship is all dependent on where your marriage status is at the 2-year mark. So if you and your spouse have divorced, you're waiting 5 years, of course, to apply for citizenship. Keep in mind that citizenship cannot be approved unless they actually approve your removal of conditions. If you and your spouse are still married, or you guys are having issues where one spouse is abusive, then you can file for removal of conditions. Not removal of conditions, citizenship, 3 years from the date of your original 2-year green card. Okay. Sorry, guys, I have to keep drinking. During naturalization, do my minor kids also get citizenship even though they were never green card holders, or do they get a green card first, then naturalization? This is a really good question. Because your kids were already born before you became a U.S. citizen, they have to get a green card first before they can naturalize, before they can become U.S. citizens. I mean, because depending on the age, they may not need to naturalize. If your children were born after you got citizenship, then they won't need to get a green card because they will be essentially be born as U.S. citizens. Naturalization would or derivative citizenship for children of naturalized citizens will depend on the age of the children at the time. At the time you become a U.S. citizen. So if, let's say, you become a U.S. citizen before your child turns 18, your child can then apply for, derivative citizenship based on, them you being a U.S. citizen and them being green card holders. Otherwise, then they would just do a normal naturalization if it's after that time. Okay. Good morning. I filed for 3. They denied 2 and kept 1, which is the I-130. I don't understand, like, your question. Who did you file for? Like, what was denied? Like, whose petition was denied? What was the reason for the denial? Somebody else is asking, USCIS officers visited my home, but home and belongings were not there. What happens next? They'll do some investigation and probably issue a decision or a notice of intent to deny if they don't believe that you have a genuine relationship with whoever you are supposed to be with. I mean, that's typically why they'll do a site visit in the first place. A site visit is usually done by the fraud unit. If they feel that there's some sort of fraud going on and this is not a genuine relationship, they'll do a site visit, and that usually so they're usually wanting to see you guys together. So from a timeline, I can't really say. Investigations really prolong cases, and it can make your case take longer than it needs to, but that's typically what will happen. Can an F1 student have a green card? If they're eligible, you can't be eligible for a green card as an F1 student. But if you're an F1 student and let's say you get married, or your parent files for you and you're eligible, you can get a green card that way. Or after you become an F1 student and then you do OPT and do H-1B and all of that, then you can become a green card holder, but not from F1 directly to green card. Good morning from City of Angels. My VAW filed on March 22nd, still showing case received, even though we know LA has loads of backlog. I mean, I don't understand your question. VAW cases are submitted to Vermont. Vermont adjudicates it, not LA. So you're looking at 2 to 3 years. So if you just submitted on March 22nd, just sit down and relax, because you got some waiting to do. Good morning, crew from San Francisco. Processing time for travel permit 2024, adjustment of status case, not VAWA, 4 to 9 months. Definitely been seeing some around like 2, 3, 4 months. Not the norm, but definitely seeing some around that time. Doesn't matter which state you file your marriage-based green card. No, you file it based on the state you live in. You can't just kind of like pick and choose based on where you live. That's what determines the address that it's going to be mailed to. Once you finish processing it for a field office, it gets sent to the field office of whatever state that you currently live in. You have to be very mindful of that, guys, especially when you change your address, to notify USCIS, because there's nothing more annoying than waiting till your interview is scheduled, attending an interview, and then the office is saying, well, we're going to have to send you to a different office because we don't have jurisdiction of your case because you never notified us that you moved to a new state or, whatever. How long does it take? How long does an I-485 take before you get a response? Same timeline, it could be like 6 to 12 months, 6 to 13 months. I always say we always have the unicorn cases where they get approved, like a green card could get approved in like 4 months. We even had one that got approved in 2 months. Again, those are not normal. So from a realistic standpoint, you want to Just put in your head that it could take like 6 to 13 months on average for most people that have no issues. Now, if you have issues like, you're receiving RFEs or notice of intent to denies, or they're doing home visits, site visits, those are going to tend to take longer for them to make a decision on. What if you submitted the adjustment of status and it got denied? The first thing we want to check is, did you, why was it denied? Why was it denied? I mean, there's no bar to reapplying again. But one thing we want to check first, make sure that you're not in deportation. That's number one. Number two, why did the case get denied? Because you need to know that in order to file a new application, so that you're not, making the same mistake over and over again. How can you protect yourself from those who marry for green card? Emmy, let me see. I mean, that's a hard question for me to answer as an immigration lawyer, because, I'm not like in the relationship. So, and, I'm not really like a relationship expert. But just from giving a personal answer, for my own self, is that, I would say do not be quick to rush into a relationship or into marriage, making sure that, the phrase basically, you and that person are equally yoked, and that that person loves you for you, one thing that I would say that I see a lot in this immigration space is the quickness in which people jump from marriage to marriage to marriage to marriage, and I'm not saying that, people don't fall in love and have a whirlwind romance and just marry. I'm speaking, I'm not speaking as a lawyer, I'm speaking as someone personally who, I've been married, going on, what year are we in? 15 years this year. And I just can't imagine, if God forbid something happened with me and myself, just jumping into another marriage, so those are some things to look at, and then, telltale signs, if you and that person are connected. And, I also think that also on the side of you, who is a U.S. citizen, it's also really important that you're mindful of who you include, or whose ears, or who has your ears, or what's the phrase going that you're listening to, because I think a lot of times immigrants are unfairly judged, or assumed to be being in relationships for green card, as opposed to them really wanting to be in a relationship, so they never even get a fighting chance. I see this a lot with people who petition for people who are doing consular processing. So, people who are coming, they're filing for them outside, and how horrendous and how horrible, they treat them when they come into the US, where it's like, okay, give me all your phones. You can't go out of the house. You can't set up anything. Oh, you think you're going to open eyes. You've come here like, you're going to leave me. So, you also have to do some self work and self search, to reduce that insecurity, because your insecurity sometimes can be something that causes, that's detrimental to your relationship. You have to trust your partner. You have to trust the relationship that, you guys have built. So it's just really hard to say, because, it's not a one size fit all, but don't be quick to get into a marriage. Get to know the person, bond with the person, go visit the person, many times, vice versa. If there's the ability to do that before, you get into a relationship, not, you met today being May, and then, you're at the courthouse in July. I know that sometimes that happens, that's life, but, in this case where you feel like you're filing and you feel like you cannot trust someone, then just wait and know that that person wants to be with you for real. And hopefully you don't find yourself in a bad situation. But again, you also have to be fair to the immigrant. You cannot assume that, someone marrying you is marrying you for green card. You have to make sure that you also treat the person like a human being, because at the end of the day, they're a human being. Okay, let me continue. I applied for extension of my work permit and travel documents through VAWA. I received the work permit of 5 years, but I don't receive the travel document. Am I worried? No, you don't need to worry. It comes at different times sometimes. Sometimes you'll get a combination card, and sometimes they'll issue the work permit really quickly because they know people need it to work, and then the travel permit usually comes a little later. So that's fine. Is travel safe with a pending case? The answer depends. It all just really depends on what stage or what phase you are in your case. So I would say that, without knowing where you are in your case, I can't really tell you whether you can travel. My husband has been waiting for almost 4 years for citizenship. He has his green card. I don't know if this is a follow-up of another question. I'm not sure what that is. If your husband is a U.S. citizen and you have a 10-year green card from a lottery and you got denied for citizenship, what is the process to get citizenship through marriage? So citizenship, if you're eligible for citizenship and you got denied, well, why did you get denied? Was it based on the timeline? Did you file too early? Or was it for something else? Because the answer to that will determine how I can answer your question. Okay. I mean, there's so many questions. I'm just trying to see questions that make sense. How long does it take to get? I already answered the question about how long does it take to get a work and travel permit. I see that a lot. Will an email be sent out before the actual green card is mailed? It depends if you have your. It depends on if you have your. If you have a USCIS account online set up. If you do, you will get the email. A lot of times also your lawyer may get the email, depending on if you've reached capacity of cases in your, in there. Otherwise, you just get it in the mail, or you can just keep checking your case status online, and it'll tell you. Can you switch locations due to job reasons, and will it affect where your VAWA case is adjudicated? And can it be delayed due to changes? It's okay to move. So I just want to be clear that I'm not saying it's not okay to move. I'm saying that if you move, you want to notify USCIS so that you can make sure that when it's time for an interview for the green card portion of your application, that it's going to the correct field office. Again, and I feel like I've said this several times and once, this just today, with VAWA cases, all cases, the decision is made in one location. It is all made in Vermont. It does not matter what state you live in. You submit your VAWA applications to Nebraska. It's all going to be transferred to Vermont. Vermont is going to make the decision. When they make the decision on your VAWA case, your file is now going to be moved to your local field office of the state that you live in. So, for example, if I live in Georgia and I file my VAWA application through Nebraska, which is where you do the initial VAWA submission, and this may be different for people who filed a few years ago because the Nebraska location just started last year. Before that, everybody was sending it to Vermont directly, but overflow, so everybody is now sending it to Nebraska. Nebraska is going to transfer it to Vermont. Vermont is going to make a decision on my case, and then once my case is decided, I'll get my VAWA approval. And then once I get my VAWA approval, my file is going to be transferred to the Atlanta field office because I'm in Atlanta. And Atlanta is going to either ask me to send a new medical if I don't have one that's up to date, or an I-864W if I submitted a few years ago when I-864Ws were removed from the application process. And they will either make a decision based on what I submit, or they will call me in for an interview in the Atlanta office. So that's how I'm just using myself as an example. So the same will apply to you if you live in New Jersey. They'll call you into the New Jersey office. If you live in Florida, they'll call you into whatever location in Florida. So hopefully that clears it out a little bit. Can a 2-year green card holder file for a parent? No, you have to be a U.S. citizen to be able to file for a parent. My green card arrived in the mail, and my husband refuses to give it to me. How long does an I-90 take? I-90s can take anywhere from 30 days to like 9 months. So it just really depends. One of the things that you might want to do is try to reach out to the law enforcement, the police, and let them know that your husband is holding your property and see if you can get that quicker, um, from your spouse. Okay. So Drama Queen says, I was denied. I guess this is the person asking about lottery. I was denied because my spouse wasn't a US citizen at the time of application. So that means you must have been doing an early application, which is when you're doing it based in 3 years. One thing to note is that as a green card holder, if you're filing on the basis of marriage for citizenship, right? Not only do you have to be a 3-year green card holder, your spouse also has to have had his citizenship for at least 3 years. So it's a rule of threes, right? 3 years marriage, 3-year green card holder. So your best bet, if he just got his citizenship, is just to count 5 years from your green card, and then you file then. So most likely it will coincide with the same time of when your husband has been a citizen for 3 years. What about my stepfather filing for me? Your stepfather can file for you. I mean, there are a few things to take into consideration. In order for your stepfather to file for you, you have to have been married. Your parent, your mother, had to have been married to him before you turned 18, in order for him to be considered a stepfather for immigration purposes. If you filed for VAWA and didn't put in your work permit and travel documents, is it a problem? It's not a problem. It's just for you. You might not be able to work, obviously, or travel. So you can just apply for it if you're eligible to apply for it. Okay. My friend has a VAWA pending. She's divorced. Now she's pregnant, but she didn't remarry. Will that create a problem in her VAWA case? No, it's fine. If she has another child, she just has to make sure she doesn't remarry. But she shouldn't lie about the child. Like, she should include that in her application. If she's called for an interview, she definitely wants to put that, amend her application at her 485 interview to include the child. We've had this happen with very many clients, who, they're divorced from their previous relationships and they get into new relationships and, get pregnant and have children. So they're not going to penalize you for that. It's just they don't want you to remarry before they make a decision on your VAWA case. David says, good morning, Ms. Aisha. Good to catch up with you again after a while. Thank you and your team for what you guys are doing in our community. You're welcome. Hope you're having an awesome day. Jennifer says, good morning. So much I've learned from you. Thank you. You're welcome. That's great. Okay, let me take a few more questions. Dream says, yes, get to know the person first because that's going to depict the future here. Yeah, okay. I think this is in response to the question that was asked about how do you prevent someone from marrying you for papers? Yeah, just try to get to know the person. Is it best to file when engaged or after marriage? Is the process faster? T. Brent, this is a good question and a good opportunity to explain the difference. So you technically cannot file for a green card when you're engaged. What you can file for if the person is not in the U.S. is a fiancé visa. If the person is in the U.S., you can't file anything for them unless you're married. Once you do get married, then you can file a green card application. And you can either do that as an adjustment of status because the person's already in the US, or you can do a consular processing because the person is not in the US. So engagement has its own requirements. If you're filing a K-1 visa, the person has to be outside of the United States. You have to have plans to be getting married within 90 days of entering the US. There also is a high penalty for the US citizen, which is that if you enter into the country and you don't marry that person or that person doesn't marry you within the 90 days, then they will not be able to adjust their status again in the US. They will have to leave the country. Like, let's say they meet somebody else, they will have to, get a waiver, leave the country, and that's how they'll be able to do it. So the penalty is really high. So you too, if you're marrying someone or if you're engaged to someone and the person is filing a fiancé visa for you, you want to make sure your relationship is really solid, and then you guys would get married because the penalty is great. The USCIS does this as a way also, to go back to the other person's question, to protect US citizens, from when they do petition for people outside of the country, based on fiance visas. They do this to protect them, just so that if someone comes in here and is like, all right, peace out, I'm out, I've touched soil here, it protects them by, it doesn't protect their heart from somebody breaking their heart, but it protects them in that, the other person's not going to be able to get the green card by virtue of them entering the country if they didn't marry them. Another way that USCIS does, to protect it is given 2-year green card. The assumption is that 2-year green cards, a lot of times you don't know each other. And so we'll give you an opportunity to do a removal of conditions after 2 years, just to make sure that your relationship is legit. If at the time they approve you and you've been married for more than 2 years, it's a fair assumption that you have a genuine marriage. I mean, why are you staying in the marriage for that long? If your marriage is not genuine. But these are some ways they have. But no system or process is error proof. Just like in relationship. I mean, remove green card aside, there are many people that enter relationships for different reasons. People enter a relationship to be gold diggers, or to take money from people, or not be. So it doesn't always, basically, with green card or no green card, people enter relationships for different reasons, and that's why the onus is on you, the person choosing to marry, not on a lawyer, not on USCIS. The onus, the responsibility is on you to make sure, that you're marrying someone for genuine reasons, and that you also know and get to know that person and that person's family, to make sure that this is the right match for you. And even when we do that, we as human beings know that no situation is perfect, and that you might plan something and you may never have intended to enter into your marriage with something happening, and then something happens, because that's just life. Okay. All right. I see y'all are having a side conversation here, so I'm going to skip those ones. My husband and I are currently separated, but my case was approved. How do I go about applying for a work permit? What case? What case was approved? Do you apply with the new married name on the I-130? Greater Stan Tanas, you apply based on what your legal name is. If you've elected to go by the new married name, that's what you'll be applying under. If you don't change your name, you don't have to apply with the new name. A lot of times I get a question saying, is it bad if I choose not to take my spouse's name? Nobody cares. USCIS doesn't care. We're 2024. This is not a patriarch. Well, it's technically not a patriarch society. So it doesn't matter whether you take your spouse's name or not. That doesn't affect you from your application. Dobie, good morning. What time frame for USCIS to reschedule a green card interview? Answer really depends. If it's going to the local field office, it can take them a couple of weeks, a few months, to either reschedule or review, and then just decide not to do another interview. So it just all depends. Can I travel to Canada as a green card holder? What can I do? Andrew Lopez, you always want to confirm what the requirements. You can travel anywhere as a green card holder. However, you want to make sure that whatever country that you have a passport for, that you need a visa or you don't need a visa to enter a new country. Because until you become a US citizen, you're a citizen of whatever country you have a passport for. The green card allows you to enter and stay in the US as a legal permanent resident, but it doesn't give you like a visa, to another country. So if you're going to Canada, you can from a US standpoint, but you want to make sure that whatever passport for the country you have, do you need a visa or do you not need a visa? So that's what you need to confirm. All right, I'm going to take a few questions and then I'm going to jump out. I've been here for 40 minutes. Take to see the response. All right, I answered that one. He came to the U.S. on a passport and has overstayed his 6 months of visitation in the U.S. He has no visa. This is a follow-up from your response from my previous question. I'm sorry, too spicy. I don't remember what your previous question is, so I can't answer this. What do you mean he has no visa? How did he enter the U.S.? How did he come in here? What do you mean on a passport? Does he have is he on ESTA? Like, did he come with a visa waiver? Or is he from Bahamas, like, or a country that allows police clearance? No, you said he came from Jamaica. So I don't understand your question. I'm sorry. How long do I need to wait to apply for a green card after I get married? There is no published timeline. You apply when you're eligible. So, if you have everything you need to apply, you can apply. But there's no requirement. How much is your consultation fee? $150. How long does it take VAWA adjusting? How long does it take in VAWA adjusting status after you receive a prima facie? VAWA cases take 2 to 3 years, so you'll fall somewhere in that window. He has a passport only, no visa at all, and has overstayed 6 months of his visitation. Yes, it will affect his case very negatively. If you're basically saying he entered into the country without a visa. Yeah. Nice. God bless you and all your family members. Thank you so much. Celaba says, do you work with people from Romania? We work with people from all over the world, in every country. If you happen to travel outside the country and you forgot your green card, what can you do? Try to go to the U.S. Embassy in the U.S. Embassy wherever you are, and see how they can assist you. Okay. I'm seeing a lot of questions about 2-year green cards arriving in the mail, husband refusing to give it to them. This particular person says they have a 2-year green card. I can already tell you're most likely going to need to do a removal of condition based on extreme cruelty and abusive behavior, which you're eligible for the minute you get your first green card. You don't have to wait 2 years to do it. Again, what I said earlier, file a police report, but I'm happy to consult with you to see if there's some abuse going on, because it sounds like it is. All right, guys. All right. Let's ask for my I-751 was approved, but a few days later it was transferred to a new office. What do I do in this situation? Nothing. If it was approved, then you don't do anything. You just get it in the mail. All right, guys. I have to jump off. I hope you guys have an amazing day. And I'll talk to you guys next time. To schedule a consultation, call 407-995-6567. If you're a client and you want to ask a question, I don't talk about confidential client matters on live. You can send a message through your client portal or shoot me an email. All right, guys. I will talk to you guys later. Bye.